we're continuing with the duty of care. And last time we looked at what we might call general types of duties of care, where we differentiate between two tests, the Kamloops and the Cooper. With the Kamloops is for established duties of care, and Cooper is for novel duties of care. With psychiatric damage, we see that when there's an established duty of care in certain topics, there can be a modified test for the duty of care. So what we're adding is, in particular circumstances, the duty of care test can be located in a certain case based on that topic. So we'll see that with psychiatric damage, we'll see it again with negligent misrepresentation at the end. So psychiatric damage is a contentious area. And I've given you sort of not really a summary, but I've given you cases from both the UK and Canada. The reason is that the textbook goes through the British cases as well as obviously the Canadian cases. But there's a differentiation in those cases. And we're going to focus on the Canadian cases because that has a different test from the UK cases. So we'll start off following the notes. We have two different types of scenarios that can be covered. So if we use a starting point, the 83 decision from the House of Lords in Aug12, this is a good entry point for psychiatric damage. So the plaintiff was a spouse and mother of victims involved in a traffic accident. At the accident, she was at home. About 2 miles away, she arrived at the hospital and was informed that her daughter had been killed in the accident, and she witnessed the extent of her son's injuries. The shock suffered from the circumstance resulted in a psychiatric illness. So with these facts, what we're looking at is there a duty of care to someone that wasn't necessarily at the initial accident, let's say. So here you have a traffic accident where the plaintiff is suing the defendant. Who would be the defendant in this case?
Hospital?
Yeah. The other driver. So what the plaintiff, the mother and spouse, is saying is to the driver of the other vehicle, not only did you cause harm to my family, but to me as well, even though I wasn't in the car. The link is the psychiatric damage. The idea is, if you recall Wilkinson and Downton, when we looked at intentional torts, that was the case where somebody plays a poor joke on Miss Wilkinson, saying that her, I think it was her husband was dead. She had to go see him immediately, and it was false, and it caused her distress, severe distress. Yeah.
In this case, belong to two different
Sorry?
categories. I mean, these two cases belong to different categories. For the Dixon case, that is intentional.
Yeah, but if you remember, we had talked about how it's a bit hard to find the intention there. What the court seemed to do was say, because you played this joke, you accept the consequences. What I'm trying to link to is, first of all, we've seen this type of incident before with Wilkinson. Secondly, the linkage comes in the psychiatric horror that the plaintiff alleges he or she suffered. So the point here is Ms. McLaughlin was not at the accident, but she's still suing for what we might call the aftermath of the accident. Now, to be more precise, in McLaughlin's case, she's saying, I saw the immediate aftermath. And what that means is, as I read out from the facts, she went to the hospital and at that moment was informed that her daughter was deceased, and her son, she witnessed the extent of his injuries. That information and the sight causes her to distress. So the question the House of Lords was given was, can she recover for psychiatric damage? Put another way, did O'Brien owe her a duty of care not to induce psychiatric damage? And the House of Lords said yes. The illness suffered by Ms. McLaughlin was reasonably foreseeable as a result of the defendant's negligence causing injuries to her family. So this is something a bit different. We might look at it as one step removed, because up until this point we've looked at plaintiffs who have been the ones who have been injured in what we might call an orthodox manner. They've been physically injured or lost money. Here, Ms. McLaughlin is one step removed insofar as she's not at the locale of the accident, but nonetheless suffers what we call psychiatric damage. In the UK, there remains a fair bit of skepticism about this area of tort, because there's a concern that people, put kind of crudely, will fake it, are trying to get money for nothing.
My understanding is that you are recognizing for the shock, not for the grief.
Mm-hmm.
So here, it's not that she was informed that her daughter was grieved, but the sight that she actually saw the injuries
of her son. And I think she, if I remember correctly, saw her daughter's body as well.
Because I think everybody will be immensely sad when learns the death of the son, if it's 1 day or 1 week or 1 month.
Yeah, I was
but
slowly
the
building up
difference
to
is,
that. Just to say that what's being compensated is not for what we might loosely call depression or sadness. Yeah, this is something that has manifested in a tangible way. PTSD. Some people suffer, like Ms. Wilkinson, something physical, a nervous breakdown, for example. So that's what we're looking at with the psychiatric damage at this point. What has been suffered? It's not you feel bad, it's something more significant than that. And that's why I took some time to look at what it was that Ms. McLaughlin endured. Now, Lord Wilberforce in the McLaughlin case went on to consider 3 elements. In Canada, we don't look at that. But McLaughlin, I think, is a good entry point to introduce this concept. We can also look at it in another way. Imagine yourself crossing a street and a car strikes you. you've suffered personal injury, but you may also suffer psychiatric damage simultaneously. Now, if we modify the facts to be the car doesn't hit you but almost hits you, you don't suffer personal injury, but there could be a claim for psychiatric damage in that case, what we might call a near-death experience. So that's not what the claim would be. I'm trying to make it a bit more tangible. And the idea is, in the courts now, that psychiatric damage is treated like physical damage, with some clear difficulties that, as I think within the last few years, mental health awareness has become a lot more prevalent, and we kind of know all that we don't know. What I mean by that is, mental health is still a bit of a mystery. And psychiatric damage is a bit of a mystery if we compare it to personal injury. If you're hit by a car, your leg is broken, an x-ray will show what happened. No x-ray shows what or reveals psychiatric damage. So there's a gap there. But for legal purposes, we treat them both as an injury in the same way. Now, where things diverge is, and Valcar brought this up a couple of weeks ago, is with litigation in the UK called the Hillsborough litigation. If any of you are soccer or football fans, you might have heard of this, that the stands in, where the hell it was, Sheffield. Sorry? Yeah. For a football match, they had let in too many people. The police didn't really do a very good job of managing things, and people were squished to death. Now, even in the 80s, they had TV. These games were televised, so they weren't in high definition, but still, you could see outlines of people being their demise, basically, or injury. So the lawsuits were based around that. That I know my family member was at the game. I saw someone wearing a red jacket being pinned against the fence. And then about a decade after that, the police who were on site sued for psychiatric distress. And in both cases, the House of Lords dismissed the claims. And if you want a sense of the skepticism of a court for psychiatric damage, or the wariness of a court in terms of expanding the duty of care, you can take a look at these decisions, the Alcock and White cases. They're referenced in the textbook. The court is very concerned about expanding the duty of care to this area in which they feel it can just go too far. Maybe if they were being honest, they say, we're not sure we can control it. So they don't mention indeterminacy, but they kind of are a bit concerned about that concept. If we recognize psychiatric damage, in these cases, if somebody watches something on TV that makes them cringe, maybe then we'll have all these cases coming to the courts. So they want to prevent that. Canada has taken a different perspective. And I've given you a few cases, but I'm going to focus on two Supreme Court cases. One is called Mustafa, and the other is Sadati. Mustafa, I think, is in the textbook, but Sadati, I don't think is. There's no, yeah. And I'd ask you to read that case. So let's look at Mustafa first. Why is Mr. Mustafa someone you don't want in your home?
A very busy man.
More than that, I would say. Not just picky.
Pain in the ass.
We might, when the doors are closed and he's on the other side, say that. You might call him a bit of a clean freak.
Perfectionist.
Not quite, he was very concerned, almost obsessive about cleanliness.
But he had already a mental disorder.
Right.
That's my objection to the decision.
Did he have a mental disorder?
There is a mental
OCD.
disorder about being obsessed. So it wasn't that the incident triggered a psychiatric damage. There was already some abnormality.
Right.
It could be that.
I
It could be
didn't think that's how the court addressed it.
Yes, but someone who is so much obsessed about the purity of the home.
Yeah, I wouldn't presume, I didn't take that as, or I should say, I don't recall there being a finding
Yeah.
that that was a mental disorder.
But there wasn't. Yeah.
We could say, that's why I asked the question, why don't we want him in our home? Because there's something that we might say is off. He's going to look at something and say, did you clean this? He won't sit down, he won't touch anything, because he's just, we might loosely call obsessive about cleanliness. But there's no diagnosed.
There is a disorder.
There is a disorder, OCD.
Yes.
No, I know, but he wasn't diagnosed with it.
But I think the defendant should have.
She's not the defendant.
I know he's a plaintiff, I'm saying, I think they should have raised that, they should have tried to
Yeah,
call
so if you
her.
read the trial level decision, they tried to make this into a bit of a religion issue. That the Muslim faith is very concerned about cleanliness. And the court, I'm not advancing that, what I'm saying is, to go, if you read the cases, speaking on behalf of anyone. The cases show this, and the court rejected that. I would say, as I said before, there's this concept called an adverse inference. If, what's his name? Mustafa's lawyers did not adduce evidence of a mental disorder or some sort of medical disorder.
Because it wasn't to their advantage to say that.
Mustafa, Mulligan.
At that time, though, I think it was. Because you had to show you had a psychiatric illness.
Yes, but they claimed that the damage occurred after, so that the company was lied. That if the company was more careful, he wouldn't have this disorder.
Right, but let's be clear about what we're talking about. There was a fly hidden in his water. So Culligan, or if you're at an office and you have one of those, what are they called? Water coolers. That's what we're talking about. So he had water delivered to his home. He had a water cooler in the home that Culligan supplied the water for. Now, what I think Constantina is saying is, he had this problem before.
Undiagnosed, I don't say that. But it goes
Yeah.
but if we, from
But
what
he's
we-
saying this caused him to go nuts. That, like, he could not function after this.
Yes, but if I was the lawyer of the defendant, I would argue that
Well, they
when
want.
somebody who is obsessed about cleanliness, it can be anything. It's a fact.
Yeah.
But this was only, it could be that, it could be something else. It wasn't the company that triggered something.
Right,
It
but
could be
Mustafa is saying it was the fly that triggered it. Right, because you were saying he had something before. And I just want to make it clear in case there's a lack of clarity about the facts. There is nothing diagnosed with Mustafa. We may say he looks like a classic case of OCD,
Okay.
but I don't think we have medical degrees. So we can't say. He looks like that, but there is no evidence put in. So his claim is Culligan delivered this contaminated water, contaminated because it had a deceased fly in it. And it just set him off. So I don't think he could go to work. He couldn't leave the house. He had a significant reaction to this because of the fly in the water. Sorry.
We should go to the.
Go ahead.
There the water was clean.
I was going to say that even if he had some sort of disorder, obsessive compulsive disorder, the kind of take your victim as you find him or her, thin skull analogy would still apply if he could have established that, well, actually, I may have been slightly psychotic,
Yeah,
but my situation has actually deteriorated
But
as a
someone
result.
with this disorder, like, he wouldn't say that, but usually obsessed about everything. So it can be inferred that even prior to the incident, he would also obsess about other things.
But I guess from a causation point of
It's
view,
not that-
if he can show the relationship between the dead fly in his water and his current
But
psychiatric.
the court dealt with that. So what was the test for the duty of care? Sorry?
If it's just the reasonable foreseeability is going to play the role here.
But that test is modified.
But in order to rely on the square rule, it must be reasonably foreseeable. Then we are going to apply the Danish square rule.
Right. So how did the court address that
As
in
a
the test?
reasonable person, not perception.
A bit more precisely, it was reasonably perceivable that a person of normal fortitude or sensibility is likely to suffer some type of psychiatric harm as a consequence of the defendant's negligence. So, if you recall, Ans Kamloops, Ans Cooper, the first stage is reasonable foreseeability. Mustafa amends that to reasonable foreseeability in a person of normal fortitude or sensibility. That's an important thing to keep in mind. This is what I'm talking about with a modified duty of care, depending on the topic. In the class of psychiatric damage, we don't use Ans Kamloops. We use what was put down in Mustafa, which has modified that test.
Sorry, another fact maybe I wrote about this one. Can any similarities between Denuco versus Stevensus?
Between, sorry?
Denuco versus Stevensus. The Walnut scheme, the duty of care, and this one, because here it is first nail and the bottle, and here is the fly.
Right, but what's how can we distinguish Donahue and Stevenson from Mustafa?
Physical damage. I think she had an upset tummy.
Well, both, we're supposed to treat psychiatric damage and physical damage as the same. But you had said there was no psychiatric damage she suffered. There was physical injury. And she was suing on that point. There was a closer connection on that point. Whereas in Mustafa, he's trying to say this caused me psychiatric damage, this being a fly in my water. And that is a bit different. I don't know if he drank the water or not. Maybe his family had drank it.
No.
But he
not in our bottle.
Yeah, he called into question all the other water he had purchased from Culligan. Because if there's a fly in this one, there could have been a rat in the last one. Something like that.
Sorry to make, for me it's not clear, the end come close from version, was, it's like that particular person has a reasonable foreseeability,
So,
and now it's a reasonable person has foreseeability? I mean, what's the
No.
difference between the two?
so ends can lose.
Yeah,
Reasonable foreseeability of harm. It's reasonably foreseeable that the defendant's negligence
the defendant.
would cause the
That
injury to
particular
the
person,
plaintiff.
To the plaintiff, so that's
Mustafa,
is generally a reasonable person will
let me
get that.
finish. Mustafa is saying we've modified this to only people who are who have normal fortitude. So if somebody is predisposed in some way, like we say in English, we put things in numbers, like, so what's a 2 to this person is a 10.
Yeah.
Where 2 is low stress, but to them it's high stress, everything. That person would likely have trouble with this aspect of the test. They would not necessarily easily fall into a person of normal fortitude or sensibility. So that is almost exactly what we're saying about Mustafa. That if we step back from it, we say the common response to a fly in someone's water is not, I can no longer work.
Basically, oversensitivity is not considered.
Yeah, so in the excerpt that you have in the text, in paragraph 9 of the decision, Chief Justice McLaughlin talks about the law does not recognize upset, disgust, anxiety, agitation, or other mental states that fall short of injury. And that's an important distinction, and Konstantina had noted it a bit earlier, and I was trying to build up to it. The idea being psychiatric damage is not about having a bad day. Psychiatric damage is about an injury. So, back to my example of being hit by a car, the injury is physical, your leg is broken. But we also look at mental injury the same way, is what the court is telling us. But it has to be beyond this threshold. If we all have bad days, we have what we might loosely call anxiety or depression. That's not what psychiatric damage is about.
Yeah, but the trial level found that he had a major depressive disorder, phobia, and anxiety. So now I know the Chief Justice found that they are not considered. But
They overruled the trial. So I think Mustafa lost at the appellate level both times,
yes.
if I'm correct. And they said this does not fall within the scope of psychiatric damage, the duty of care. So that the trial judge was wrong.
Okay.
Okay.
Just really clarity purposes, are you familiar with the case that just took place in the Court of Appeal in DC last week? It was basically a case where a husband and wife were basically jaywalking, and a motorist pretty much saw them from distance, but obviously didn't slow down because of reasonable driver light. And he ended up actually hitting the wife. And the husband just wanted to claim for psychiatric damage because he said seeing his wife being hit, he pretty much got diagnosed with PTSD.
Yeah.
Prevented from work for 5 years. So
Well, and also he was in the zone of danger, so to speak. He could have been hit. So here, if you recall what we were talking about last week with the evolution of the duty of care, psychiatric damage is a real problematic area. Because, as I said, psychiatric damage is harder to detect than broken limbs. It's harder to put into evidence. So the court is trying to find a balance with recognizing psychiatric damage, but at the same time not expanding this duty of care so far that it could be seen as encompassing a wide range of what we might call negative mental states. And that's what the Chief Justice is saying about the law doesn't recognize upset, distress, anxiety, things that fall short of personal injury. Yeah.
Is this not just a question of medical evidence?
We'll get to that, because everything changes with severity. So, just checking if there's anything else that,
Was this case an established issue or novel issue?
they use the Ans-Kamloops test.
So it's established.
Yeah. Right. But after Mustafa, the test is modified. So we don't use Ans-Kamloops. We use a modified Ans-Kamloops where it's reasonable foreseeability of harm in a person of normal fortitude and sensibility.
Does it also modify Ans Cooper?
They didn't address that. So I think for it to fall within Ans Cooper, it would have to be something quite novel, and nothing comes to mind at this point, because it would have to be, if it's psychiatric damage, it's psychiatric damage, is what they're saying. And that arguably large scope is covered by the modified Ans test.
And this is not for physical damage.
No. So if we had a person who suffered physical damage and claimed psychiatric damage, we have the two tests. So in my example of a pedestrian being struck by a car, and Kamloops, was it reasonably foreseeable, was there proximity, any policy reasons, and then the Mustafa modified Ans-Kamloops for psychiatric damage, would a person of normal fortitude and sensibility have suffered harm? And I think in that case we can say, well, anybody who gets hit by a car, the normal person will probably suffer in different ways. Like, it's reasonably foreseeable that someone who's struck by a car, in Malkar's example, even where the husband wasn't, he almost was, but seeing his wife struck, it's reasonably foreseeable that that would create an injury of psychiatric damage.
But also, I think there's also like notice actors which should be used involved, because like it only was over 25% of the total damages. But
Yeah, we'll deal with that after, with causation. So Mustafa, I think in one sense, is an understandable decision. Because you could imagine the headlines in the news if it went his way. You know, put a bug in your food, you'll get psychiatric damage. Yeah. 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 So, yeah, I think I think we can understand what the court was doing in this case. Jimmy?
So, I know it may be a side issue, but I look at the damages awarded at the trial level to Mustafa and I compare it to Sadati, and I'm trying to...
Well, let's go through Sadati first, and then look at, because Sadati is I think, a very different decision in what the court was doing. So with Mustafa, I think we have the court expressing some of the points we've looked at before. Be concerned about expanding a duty of care that's hard to handle, may lead to indeterminacy, and also tries to balance this very troubling area of psychiatric damage. That seems to be parked in Sadati. Factually, what happened in Sadati?
Sadati was involved in a series of accidents, vehicle accidents, and he suffered physical injury, and his condition got worse with each accident. And starting from the second accident, he suffered psychiatric damage as well.
What was it that she suffered?
First he had a pain.
Yeah, but after the second accident, what were her psychological injuries?
Personality change and cognitive
Personality
difficulties.
change.
Yeah. So this is different. This is someone who, I'm not suffering from depression, or I'm not constantly anxious about going out the door in case I get hit. This is a personality change. Yeah, which I'm not 100% sure what they were. But if we just, for simplicity, focus on personality change, that's different. That speaks to something that as yet we haven't seen in cases. You're in a car accident, and the injury you suffer is you're basically a different person. Yeah.
Is it because in this case the damage was somewhat or seemed irreversible or more substantial than Mustafa?
No. So in Mustafa, did Mustafa have to, did the Supreme Court say he had to produce evidence of medical injury? Sorry?
Not expert.
Yeah. So what the court in Mustafa said was, and this is expanded upon in Sadati, a plaintiff does not have to be suffering from a recognized psychiatric injury.
Well, I think the distinction was drawn in Sadati versus Mustafa is Sadati actually sustained a physical injury as well. And I think that the line is when someone sustains a physical injury, then...
But Mustafa didn't.
But Sadati did. Sadati did. He had 5 accidents.
Well, in all of the 5 accidents, I'm sure she did. Like, I'm not driving in Sadati.
Excuse me, why he had 5 accidents, that's I don't understand.
Maybe he had a problem.
She drove with her eyes closed, I don't know.
I think someone was doing a voodoo over.
She had remarkable bad luck. Maybe she's a poor driver. Like, I don't know. That was not explored in the case, nor was it germane to this litigation because she was suing for the defendant in the second of the 5 accidents.
Yeah, here's the paragraph. Distinct rules which operate to preclude liability in cases of mental injury, but not in cases of physical injury, should not be elected. So basically, the duty of care from Mustafa is pure psych issue, but Sadati had a physical injury plus psych. Therefore, I guess.
Yeah, but this was more the psychiatric death in Sadati that they were looking at. And what the court says in Sadati is,
it was going to be some physical and psychiatric.
I just wonder how, from evidentiary point of view, you have 5 accidents.
I'm
So
getting-
now you are suing in the second. How can you
Because
say
the
that this
personality
change was
change-
for the second? I mean, she
But
had
I'm getting
obviously
to it.
5.
I'm working on it. I may be slow, but I am.
The alternative is to have 5 accidents and then figure it out.
Yeah, so the court said that Sadati did not have, in order to recover damages, she did not have to prove she had a recognized psychiatric injury. What does that mean?
But it was enough that friends and family was giving evidence. They-
Right, we'll get to that in a minute, but precisely it means you do not have to have medical evidence of a recognized psychiatric injury. So there's something called the DSM, which stands for something I forget now, but that's basically the Bible of mental health, the DSM. And if it's not in the DSM, the thinking used to be, then it can't be compensated. The Supreme Court of Canada is putting that aside and saying, if you suffer psychiatric damage, you do not need medical evidence to corroborate that you are suffering this psychiatric damage. That's an important point that must be stressed. Because orthodox litigation is, you have as Enrico said, you have a battle of experts. I get my doctor that says, you're just a wimp. You get your doctor that says, this is catastrophic.
Diagnostic and Statistical Manual of Mental Disorders.
Thank you.
DSM.
Thank you.
What is it again?
You just look it up. Diagnostic and
You're causing me
Statistical Manual
psychiatric
of Mental Disorders.
So,
That's the DSM.
Zipak gives diagnosis again.
So,
so why would the court modify, yes,
I'm trying to reconcile the two decisions. I'm not sure that Sadati is all that helpful. So in Mustafa, it's serious and prolonged injury, and in Sadati, it's you can come along and bring some. You could potentially demonstrate, presumably serious and prolonged through non-expert.
did Mustafa have that? Did he have people testifying to that? No.
I don't.
So let's finish the test, and then we'll come back to reconciling the two. Because after we look at that Sadati doesn't have to have medical evidence, the question is, what evidence does she need? And the court says, friends and family.
But it's more than just the evidence. It's about what must the nature of the injury be.
But if you're alleging personality change, and the court says you don't have to have a doctor verify that, you can bring in friends and family, isn't it about both? And what I would suggest is, look at it from the defendant's point of view. Traditionally, you'd say, your expert is discredited, my expert is better. That's gone. Then, what do? You say, well, this person's arguing that they have a personality change. What's that? Well, they bring in their friends and family that say they're a different person. How do you attack that? This is the difficulty. If you don't have to meet the medical threshold, and it comes down to basically how good are your witnesses, and for the defense, how good are you at cross-examination? Because that's the only way to attack the plaintiff's witnesses. This becomes something almost kind of outside of the law. This becomes, and I'll point you to who wrote the decision, Mr. Justice Brown. Mr. Justice Brown came from Alberta. He was an academic in tort and evidence. And you see exactly these 2 points brought out here with a leaning more towards evidence. To him, everything can be solved by evidence. If the plaintiff doesn't have the evidence, then they can't make out their claim. So the question about Mustafa, he didn't have the evidence. He didn't have the evidence that he was a person of reasonable fortitude and sensibility. Sadati did. Yemi.
I'm sorry, I didn't get that. That's what Chief Justice McLaughlin was saying, though.
In which?
In Mustafa, I think she was trying to say, listen, it can't be your feathers are ruffled, you're just upset.
Right.
There has to be something more, and that's what I'm trying
And
to
this is
define.
where the order of the decisions complicates things. If we had Mustafa after Sadati, I think it might have made a bit more sense, but we have it the other way around, where we have the court saying there has to be a threshold, there has to be a stop line, which is good in, what was it, 2006? No, Mustafa, 2006, 2008, sorry. 2008, that was what they were concerned about. Almost 10 years later, it seems like the parameters are taken away. And McLaughlin was on both courts. So if she found something to oppose, she had the opportunity. So Sadati is the law that says you don't have to show medical, bring in a medical expert. You can rely on friends and family. So,
This doesn't make sense for me. Usually friends and family will support any argument, and how the other part can cross-examine this fact if they are really...
this is the question I was asking earlier. Why would the court go this route? We can disagree with it, but I think it's important to think of, well, why are they doing this?
Maybe because mental health is an area where even the medical associations are not sure of which are mental illnesses and which are not. It's even as well, it changes sometimes. They are not classified as mental illnesses, whereas some argue that they should because they impact maybe more.
I think that's part of, Anna?
Yeah, but in this specific case, how you can prove by medical evidence changing of personalities? They compare one person in a certain period of time with another, with the same person after. This person you can't provide any assessment for the first stage. So only this evidence, friends and family can assess.
Yeah, I think the court went that way because especially like in psychiatric measures, like it's different between the individuals, and yeah, everyone has a different effect. Things affect him different from other people. So if I'm saying, for example, like I'm suffering from depression because of that accident, the other party can easily bring some also medical expert saying that usually those kind of accidents don't affect the mental health of the person. So that's why maybe we need like evidence from family and friends.
Okay. Are you going to say something negative or?
Something different.
Okay. You and then. What are you going to say?
Am I?
Me? Okay, you can look me out.
I think court, if a a medical report is requested, there will be an additional condition for the test. In the test, which is applied to the duty of care issues, there is no medical condition requirements for application of Hans-Klumps and Cooper test. Asking for an additional condition such as a medical report will be an additional requirement for the test.
I wasn't sure where we're going. Yeah. So, in sort of in summary, then it seems that the court is concerned about marginalizing people in this category that is not as well understood, that may be hard to prove based on the state of science or medical sciences at the time. So the court has made a decision that they're going to open up this one area in contrast to the other duties of care, where arguably they've constricted them. And I think it's an important contrast to keep in mind, because if we're looking at consistency, we say, well, why are they doing that here? Why the psychiatric damage treatment is different from the other duties of care. And that's why I really implore you to think about why the decision was made, and then we can pick it apart. But the Supreme Court, as to reiterate, it seems to be suggesting that this is an area that is difficult because of the state of medical science, because we still don't really know that much about this area, and the court is concerned about marginalizing people or putting people who may fall into these gray areas, putting them outside of the law's capacity to provide a remedy. So what they do is they say, we're not going to make it about expert evidence. We're basically going to make this about evidence simple. Particularly, who are your witnesses and how good are they? So, you've had your
I
hand.
just want to understand,
Yeah.
and if it comes across negatively, my
No. I wanted to say, I didn't want to go into picking things apart until we completed looking at why they made the decision. That's why I was asking.
Sure, I think in my head, on any basis, and I want to clarify that this is the case, on any basis, any plaintiff who claims their psychiatric injury needs to either show serious and prolonged injury / what they say in Sadati, requisite degree of disturbance.
Mm-hmm.
I see that as a kind of threshold, and that's the point of clarity. And then I was going to add that perhaps the evidentiary burden is perhaps lightened for the plaintiff, as in you don't need to call an expert, but you still need to show requisite degree of disturbance, whatever that means, / prolonged, serious and prolonged injury. And then the other.
I don't know about the prolonged part. I agree with you that that would be a reasonable characterization of a threshold. I don't get the impression from Sadati that they're putting thresholds on that's beyond the evidence.
They do talk about the claimant's task in establishing is to show, this paragraph 37, to show the requisite degree of disturbance, whatever that means.
Right, but that doesn't say anything about prolonged suffering. That's my point. I don't want people to think that, well, if she suffered for a week, then it's not. Because the court doesn't say that.
But must we not read the two cases together to
Well, but that's another thing. How do we reconcile them? I think that's a difficulty that we can look at. But what I'm trying to do is sort of package things because there are a lot of issues just within these two cases.
And, and if I was a defendant's counsel, presumably I can still have the person examined.
Yeah.
And yes, even if you bring, your entire clan to come and give evidence of your personality change, I can presumably still try to raise expert evidence to counter that.
I don't know if you can. What expert evidence? Because if you bring in medical, I'll get to it in a minute. If you bring in your medical witnesses, the way this case is constructed, I don't think there's a way that a court could let that trump. Because it's almost doing through the back door what the Supreme Court says can't be done at the front.
Except they say in paragraph 38 that expert evidence can assist in determining whether or not mental injury has been proven. It's just not a requirement.
Right, but that, for the plaintiff.
It must follow for the defendant as well, presumably.
Why would the plaintiff not have a burden of expert evidence, but the defendant could win the case by bringing in an expert?
No, it's going to be an evaluated exercise, clearly. Plaintiff, no expert, and defendant expert.
Right, but I think what I'm pointing out is, in particular, if we look at it from the defense counsel's point of view, you have a real problem.
You might as well throw in the towel. Because unless you can cross-examine the witnesses,
That's on a surface level. I think that's generally all that we can say, because I'm pretty sure Moorhead's lawyers did everything they could to say the friends and family are nuts. So you really have to show that. You have to, what's called an evidence, you have to impeach the witnesses. You have to show that these witnesses are not reliable. And I suggest you're taking a risk if you're relying on medical expert evidence. Because if that is the reason that you win, I wonder if that gets upheld on appeal. Because if the plaintiff's burden is not to meet a medical evidence threshold, I think it's hard to say, well, the defense medical expert helped save them.
Don't you think lawyers prefer expert evidence to factual evidence?
Sure, but this isn't about what lawyers prefer. That's why I said, why is the court doing this? If the premise of the court is we want to make sure this category of injury called psychiatric damage is not subject to difficulties that do an injustice, broadly conceived. They're not concerned about what the lawyers think. They're concerned about, are we doing right by potential plaintiffs? And they're also, I'd say, as a secondary point, particularly with Mr. Justice Brown, saying we believe lawyers have the requisite skills to make this work. Because they're saying, well, you know how to cross-examine, go do it. So I agree with you. I think there's a real bind for a defense lawyer in this kind of a psychiatric damage scenario. Because your orthodox tools, like expert evidence, are put aside. Now, if the plaintiff does bring in an expert, great. But a savvy plaintiff lawyer, I bet doesn't go that route. Because you don't want it to be a battle of experts. You want to mirror the outcome of Sadati. Zita.
I'm just clarifying, is it only about personality change
No.
or any psychiatric?
Any. This is a new threshold. So if we step back, we can say, what the hell are they doing? But that's why I asked the question first, why are they doing this? And then we can debate, well, maybe in trying to do justice to this category of plaintiff, they've gone too far. That's fair. But we can't just say, this doesn't work.
But I'm surprised because for personality changes, I might say yes, friends and family knows better how was the personality before and how it changed.
Exactly.
Because an expert, what an expert can say, I see him now and I didn't see it before, so he can't assess any change,
And that's
right?
why it's a
But
good
any
example.
any psychological damage? I mean, I'm surprised because there are some other forms, I guess, of psychiatric sicknesses which can be measured
Yeah.
better by experts than.
But
can
then
be.
if we go back to the Mustafa case, if Mustafa had friends and family, if Mustafa was litigated now, if he had friends and family testifying, would he have won?
But that's a different sickness. I mean, that's the point, that's a different.
But he doesn't have to have a medically recognized illness.
He would have lost.
But he had,
Sorry?
but he had.
No, he didn't.
He would have lost.
Mustafa had, no?
No, that's why I was clarifying.
The facts point that
Yeah, it's
that
pointing,
there was
yeah.
no,
Like, it just, we may see somebody and think, that guy's crazy. That's not a factual diagnosis. That's what we had in Mustafa.
I'm also puzzled a little bit from the fact that personality changes happens. I mean, not only because of accidents, I mean, a normal person is changing.
Yep,
And what about real death experiences? I mean, people really change dramatically
Right.
of an accident.
but it depends on the circumstances. Did it arise in a circumstance of tort? That's the question.
Yeah, but is the personality change bad or good, you know? I mean,
That would be a novel
you know what
case.
I mean? I can imagine the
Yeah.
personality change, actually. You know, maybe he was a drinker before and now he just doesn't have any more drinks. Then the family goes to, you know.
Sure.
I want to have fun and I
have two
don't
questions.
anymore.
Person Oil, I have two more questions. Please, do you think this case seems too remote? Do you think it's likely to be nullified in the future?
What do you mean by too remote?
Well, I mean, because of psychiatric evidence and
Sorry?
because of psychiatric evidence, the medical record, medical evidence, somehow it's removed.
Because there is no
No,
record for
no medical evidence.
Yeah.
So based on that, I would say it's too remote. So my feeling is that maybe it's likely to be nullified in the future.
Nullified in the future.
Do you think so?
I'm thinking about it. We'll keep badgering the witness.
Because another thing is, for example, I have a case in the past, not different scenario. In that case, all witnesses are conspiring. They conspire.
Yeah.
So that's why maybe they are conspiring.
But-
Who knows? Because
Okay.
justice I just did, what on the paper. Yes, what on the paper.
But the court isn't concerned with that as much as it's saying, we put trust in the litigation process. That if there's a conspiracy, it's up to the defense counsel to get that evidence out of the witnesses. So I don't know if it's necessarily too remote. That, keeping aside that that's the last part of the negligence claim that we look at. I think here, is it too remote? Is it too broad, would be the question that I think you're asking. Is it too easy for a plaintiff to show that they suffered psychiatric damage? That may be. That may be a legitimate criticism of the law as it's stated now. But I think the Supreme Court's response would be, it's up to you as the lawyer to cross-examine and get the evidence. And then, so, just a minute. your second question, there were motions.
So I
Oh,
follow.
will it be nullified?
Yeah.
I don't see this being overruled.
Maybe. Who knows?
Maybe we'll win the lottery.
But basically, you are saying the defendant side of the law is the de facto, right?
Is what?
Defendant side of the law is they did the not good job.
No, I didn't say that. I think,
I'm just.
no, in Sadati, as I said, actually, I think Moorhead did, I'm sure Moorhead's lawyers did everything they could. But the case shows that if the witnesses can't be impeached, you have a problem. So on the point of it being overruled, I don't see it being overruled because, for the reasons that we had talked about when I asked the question, why did the court go this route? Because I suggest that the court's perspective is, this is in the public interest. And we, the court, have faith in the litigation process that at the end of the case, the outcome will be the outcome and the way it should be. That may be unsettling, that may be the subject of criticism, and I think that's entirely fair. But I don't see Sadati being overruled in RICO.
Just to get this important point, Mustafa still safeguards this type of litigation because in Mustafa from 5 p.m. the plaintiff didn't can't convince anybody that he wasn't crazy to begin with.
Yeah.
That's what this court case is saying. And
What happens if you have no friends?
It's also unfair to take somebody, for instance, if I was a self-represented litigant, to put that burden on me, that I would have to expert evidence. We're looking at this from
Sure. That'd be another point, yeah.
That's another option.
There's a cost aspect to it.
Yeah.
You have to hire the expert witness.
That's right. And you know, the problem is, I know now personal injury lawyers get indemnified now by insurance.
Yeah.
Cases you lose, which happens, it's still not very popular. So it's an added cost. But again, Mustafa still saves the day because at the end of you have to prove that you had normal fortitude before you bring in. So I think that's what the witnesses in Sudan did. He said, look, you are this, that, and he's like this now.
Yeah, but I think
it was nuts to begin with.
I'm not sure that Mustafa puts a firm parameter on it. I wonder if Mustafa is just a particular set of facts that fell below. But I look at Sadati as creating some legitimate questions about how to proceed in this area of law. So just 1 minute. When you become a lawyer, you get every week the Ontario reports. Have you heard of these? So the Ontario reports are cases that are published every week. If you have a chance, take a look at one now. The first few pages, they're pages of expert witnesses advertising their services. Just to give you an indication of, this is a big industry, expert witnesses.
That's what I'm going to say.
Okay.
Yeah, I think that the direction maybe to see that the expert evidence is not so important. And also I think the colleagues, the data is trying to put the physical injuries and the mental injuries on an equal footing to show that the mental injuries is not so much difference from physical injuries. So, I mean, in the physical damages, the expert evidence is important evidence, but not so necessary. So it's equal in mental damages.
Yeah, I understand, but like, I guess the problem I have is, if you are struck by a car, you're going to have a medical expert come in and say, here's the x-ray. This guy's leg was shattered in these places, and friends and family aren't going to do anything for that. So I see a divergence in terms of the physical injury and the psychiatric damage on that level, that it's more tangible in the physical, but you would most likely have expert testimony to talk about these points. And if we allow it there, are we missing something in the psychiatric? Putting aside that, there's a long history, a negative history of expert witnesses being, basically you buy them. That's sort of the sullied version of it. Zita and then...
I'm just wondering, how was this evidentiary problem solved that there was 5 accidents? I just don't understand how can you say that all this happened because of one accident
Because
when you had 5?
The friends and family say after the second one, the personality changed.
Yes, after the second one, but would this personality change happens if there is no first one? You know what I mean? The personality change happened because he had series of accidents, right?
Yeah,
So
but...
now you put the burden, the blame on the second one.
Yeah.
But let's say he had 10 accidents before, and now that was the last drop in your glass, and now you put all the blame on the 10.
But wouldn't that come down to the evidence? And the evidence was, after the second accident, she suffered a personality change.
She was looking for third, fourth, and then...
Yeah, after the personality change, she drove even worse. But the evidence, that's what I'm saying, the evidence suggests that was not the case. That after the first accident, something happened, but it was the second one where she suffered the psychiatric damage of personality change. And that the subsequent accidents didn't do anything.
And they didn't care, yeah.
So if the testimony is everything started after accident 2, how do you, it goes back to my question, as a defense attorney, how do you deal with that? Sorry, Ebra, and then I'll turn to you guys.
Yeah, anyway, I don't think it's a new approach, because if we compare it to the criminal law, and you have like a defense of a mental disorder, after all, it's a question of law, not a question of fact. So the court is going to decide, no matter what the medical evidence, that these persons suffering from mental disorder or not, regardless of the medical evidence.
Okay, well, I don't know criminal law that well, but it does raise some questions, but maybe it's not good to ask. Leon?
I was just to say something in addition to what you have mentioned in terms of the evidence. Obviously, Sadati did have some evidence to corroborate what lay witnesses were advising about his change of personality and problems with prevention. There is no court that would just take a lay witness statement as something actually proving the fact, unless there is something more corroborating in terms of other medical records. For example, family doctor, psychologist that was treating that person, and nobody was providing an opinion on a threshold. Those things were sufficient enough for the court to decide about permanent and serious injury, which is pretty much a medical legal test, which doesn't exclude the court to make an opinion about that by itself, based on medical records available and probably produced during the trial. And also about the expert witnesses, as you have said it, I don't think that defense counsel would even have a right to examine Sadati by his or her own psychiatrist. If there is no expert evidence led by the plaintiff, then obviously they're not entitled to have an examination.
That's why I was saying...
Under the rules, you said that. So you cannot just tell the plaintiff, look, you claim for your fractured leg, but I'm going to examine you by a psychiatrist as well, and by a gynecologist and obstetrician at the same time, just to check on you whether you're okay. No, this is not how the process goes in the court. either you can just impeach the expert that is being called. So what has happened probably, and I'm just thinking, there was a plaintiff's counsel who didn't prepare well, didn't have an expert evidence, because this is a true rarity. Everyone gets an expert. It's too risky. It's too risky. He didn't do it. The jury loved Sadati, and they gave him. They said even, emotional, psychiatric, whatever, they're giving you everything. And then it came to an appeal. The appeal court said, oh, no, you cannot do that without the expert. And the Supreme Court said, yes, you can do it without the expert, because the judges are supposed to think, not just get a summary from an expert. You have records out, read it, make your own conclusion. They're lay witnesses, bingo, you don't need the psychiatrist to tell you whether there's DSM-5 or whatever diagnosis, you can figure it out. So this is what I'm thinking.
Well, I've worked on cases that went to the Supreme Court of Canada, and the amount of preparation is ridiculous. So everything would have been covered. And when you go to the Supreme Court, there are people that specialize in appellate advocacy.
The only thing I was saying, that at the trial level,
I know.
plaintiff's counsel was late with that evidence.
Yeah.
And he didn't call an expert. And
No, I understood that. It's just,
They choose not to have it.
well, sometimes you don't have a time. Sometimes you think it's gonna settle, it doesn't settle.
Maybe.
Yeah.
So you just go there without, you go without that evidence, and you pray to Lord that something will happen.
I understand.
You're gonna get it.
I understand. All I'm saying is, it's less likely when you get to the Supreme Court level that be successful. But maybe they gamble, your point.
There is no new evidence at the appellate level or at the level of Supreme Court.
No, but
Is that-
even to be granted leave to appeal twice, if the court thought that plaintiff's counsel basically was trying to do things on the sheet or whatever, I don't think they would have taken the lead, let alone had this result. I'm not trying to say you're wrong. What I'm saying is, I don't want to underplay how tough it is to get leave to appeal to the Supreme Court.
I bet it's horrendous.
And then to win. That's my only point on it.
My question to you, if you have medical records, for example, of a family doctor, who routinely prescribes antidepressants to anyone who shows up and say, well, I feel down, my wife is ugly, my husband is a jerk, whatever, my wife sucks, here you go. Anything else, and if there is a record, then month by month, where you're getting those things shoved down your throat, nobody knows whether you're taking those prescriptions or not. There is a corroborating story from the family about the change of personality. You have pretty much very clear record. You have the evidence. That is it. You don't need to call an expert. Why would you call the expert? To tell you that, yes, those are antidepressants.
But sometimes people may not want to disclose their privacy.
Sure.
Because of this, they may not want to get an expert. In this situation, we don't know, maybe Sadati didn't want to disclose her or his psychiatric situation in detail. That can be a reason.
I know this is not a course on civil procedure, but are you able to clarify whether or not an examination can be sought by an adverse party?
And then what kind of examination?
A health practitioner. Yes.
Only if it's put in issue.
Well, I mean, he says he said he was suffering a psychiatric injury, presumably.
Yeah, but if they're not saying that this is something medical, that's what we're down to, right? That's what I'm saying. If you can't, if as a defense, you can't bring in the medical stuff. You're left to cross-examine the friends and family.
Would you be able to, would there be scope to bring a motion to say at the preliminary stage, this is in fact, you are maybe not explicitly suggesting?
I don't know for sure, but I'd be surprised if Moorhead didn't bring motions on this.
As a general question, I mean, if somebody comes along to court and
Yeah.
says, I've had a personality just or change, I
Yeah,
presume that
like there'd be lots of motions.
to try to have an examination.
On different aspects, not just that. Just to say, like, there's no cause of action, I think will be the first one. Throw this out. This person's saying they're a different person now. What the hell is that? If that would be the argument, right? So, would there be motions? I'm certain there would be, and I'd be very surprised if there weren't in this particular litigation. So we'll take a break, say 7:40, so at 8, and we'll come back to a health professional's duty to inform. If you came in a bit late, the attendance is 7.
You know, where is the Scotland? Yes.
They used, when I did my JD, they had on-campus interviews first, where it was like speed dating. So they, like, you were in a hall, and each firm had a booth, and you interviewed with them for 12 minutes. They had 3 minutes to write about you, and then you moved on to the next one. So a health professional's duty to inform. You see this a bit also when we look at causation. The idea here is what constitutes informed consent to a medical procedure. So if we look at rival accused, there's a 2% chance of risk of stroke leading to paralysis. And that this had to be communicated to the patient. And we get these kinds of slim percentages in medical cases. That there's a duty on the medical professional to warn. So the Healthcare Consent Act 1996, informed consent provides that for consent to be valid, it must be informed, and defines informed in terms similar to the common law principles. And we'll come back to this in product liability in a few cases. Manufacturers and suppliers duty to warn, Lambert and Masterplex. Actually, let's go to the Hollis case. That's the one that I think is more useful. So this was litigation surrounding silicone breast implants. And the idea was, did Dow have to warn about these the risk. With the added problem of the surgery is conducted by a plastic surgeon. So there's an intermediary, and the note I give you the term learned intermediary. So did the learned intermediary do something incorrect? So there was a duty on Dow, the manufacturer, to warn consumers about the inherent dangers of the product, that there might be ruptures in the implants which could cause harm. And I mentioned this case because I think everybody's seen this on the news at some point, that some women developed cancer because the silicone seeped out of the implant and into their body. So this was has been a very big area of litigation. Duty of care owed by a barrister. Things kind of were pretty easy if you were a barrister. The threshold was egregious error. Why would that be a low threshold, sorry, a high threshold for a plaintiff to meet? The idea of an egregious error.
If the standard is too low, then the barrister will take a very defensive strategies.
Yeah, but if it's egregious error, is that high or low in terms of a threshold?
High.
Very high.
Yeah. Belkar?
It would, like, I guess, like, from a medical standpoint, it would depart from the standard that certain medical professionals are held to.
Mm-hmm. So it wouldn't just be an error. It had to be egregious, like so bad that it allowed someone to sue. So by 2005, the Ontario Court of Appeal had rejected that and said the judgment calls made by lawyers are no more difficult than those made by other professionals. So there is no justification to depart from a standard of reasonableness. And this anticipates our discussion about standard of care, breach. Depending on who the defendant is, the standard of care can be adapted. But if you adapt it to a point that sets the threshold too high, that almost acts as a defense or a benefit for a professional. I think the others are kind of straightforward. So I want to get into standard of care. What is, or how do you understand the standard of care? What does this mean?
How you're gonna carry your duty.
Sorry?
How you're carrying out your duty.
Yeah, so if we, again, we have these 4 steps of duty, standard, causation, and remoteness. If we look at the duty, we're asking, did the defendant have a duty of care that it owed to the plaintiff? And if we answer yes, then the question is, well, did the defendant fall below that duty? Did they fall below the standard of care that is expected? And generally, we look at that as a reasonable person test. So Arlen and Taylor is a case that's often cited for this. The test is, what would a reasonable and prudent person in the circumstances have done? And what this means is, if there's a duty of care, the assessment of whether or not that duty was breached is on an objective standard of the reasonable, prudent person in those circumstances. But, and this was cited in Arlen, the court can't insert itself into that. It can't be subjective. You can't say, well, I would have done something different. So the point is reiterated in Ryan and Victoria City. A person must exercise a standard of care that would be expected of an ordinary, reasonable, and prudent person in the same circumstances. The measure of what is reasonable depends on the facts of each case, including the likelihood of a known or foreseeable harm, the gravity of that harm, and the burden or cost which would be incurred to prevent the injury. So Ryan outlines some of the considerations that go into that assessment of whether or not a standard of care has been breached. And the most common really is cost. And the one that you might see more of is the cost of risk avoidance. So if you go to that subheading, you have the case of Vaughan versus Halifax Dartmouth Bridge. So a bridge was operated and maintained by Halifax, and it was painted by them, plus the paint was blown by the wind onto nearby cars. The owner of one of the cars sued. The defendant argued it had taken all necessary and proper measures to prevent or minimize paint from dripping, and so it was not careless. So here we see Halifax is not disputing that there would have been a duty of care. They're saying we didn't breach that duty. We didn't fall below the standard of, in this case, a reasonable, prudent bridge commission. But the cost argument was not accepted by the court. Why? Yeah.
Because it discharges the duty in a low-cost effort, like just posting having some notices.
Yeah.
And what was in danger, like the task of painting the car, is expensive. So if you compare the danger of something expensive and what they could do was not something.
And even though this is a trial level decision, it's an informative decision because it tells us that when a defendant argues that the cost is too high, the defendant needs to be pretty sure that that is the case. Because in Vaughan, there is a very simple, discreet, as Constantina said, cheap way of doing that, dealing with this, and that was just putting up notices in the area. We're painting the bridge, take proper care. And that would have cost a minimal amount.
Yeah, but what the drivers could do? Don't pass the bridge?
No, well, these were more people who lived in the area. So what people could do, some people have car covers, you could park somewhere else. No. So the court will engage in a bit of an economic analysis to see, well, if you're saying it was too expensive, we will push you on that. And here we see a really cost-effective means of avoiding liability. But in Bateman and Doiron, the New Brunswick Court of Appeal accepted the financial argument that Moncton Hospital had no choice but to grant privileges to general practitioners in order to fully staff its emergency department. So here, the issue was staffing the emergency room. Who should be the doctors staffing an emergency room? And the hospital said we could only afford to have general practitioners do this, as opposed to whom? Well, trained emergency room surgeons, people who actually train in this kind of pressure environment, as opposed to a general practitioner who has an office, schedules appointments, and deals in a very different atmosphere. The court accepted that the hospital could only staff the emergency room this way. And I think I've given you a portion of the decision. To suggest that the defendant, Moncton Hospital, might be reasonably expected by the community to staff the emergency department with physicians qualified as expert in the management of critically ill patients does not meet the test of reality, nor is it a reasonably expected community standard. So here we see, within the medical context, a very different decision made. What can we take from that? Well, the court accepted the financial argument based upon what the cost would have been to staff the emergency room in the way that Bateman alleged was appropriate. And the court accepted that that cost would not have been, or in the court's words, would not have met the test of reality. The hospital could not function with that kind of financial burden.
But isn't this New Brunswick Court of Appeal decision is purely in the setting of financial public health care?
Yeah.
Probably it would be a different reasoning in some USA court.
In a U.S.?
Yeah.
Oh, sure, maybe. But I put in the dissent just to note that the dissent criticizing the staffing and administrative practices of the emergency department to say if cost is a point of contention, you have readily available arguments on either side here. So we look at law estate. In this case, hospital healthcare provider is being sued for not deploying certain items known to medical science. Lack of resources was due to a financial decision. The court says the severity of the harm that may occur to the patient who is permitted to go undiagnosed outweighs the financial harm that will occur if the matter is diagnosed. So here we have something going against, a decision going against the financial argument. So what we take from this is not that courts seem to be all over the place, but within the circumstances of these cases, the courts have found that the financial argument is inadequate, is not acceptable.
In some cases.
Yeah. Now, the case that I have trouble with is Bingley versus Morrison Fuels. And I'll give you a minute to reread. I gave you the summary, right? So I'll give you a minute to reread that.
Which case? William Morrison?
Yes. problem I have with this case is I think the standard was set too high, or is an improper standard. Briefly, the facts. You have a house that had oil heating in '79. The furnace was taken out, and the nozzle, the way that the oil will be pumped into the home on the exterior of the house, so people don't have to go into the house to put oil in, was turned upside down, I think it was. And covered. Many years later, Morrison Fuels sends a driver who was not the most alert, misreads the ticket, thinks he has the right house, doesn't really clue into how hard it is for him to open this nozzle. He's determined to pump oil into this basement, and he succeeds. And the damage caused was more than $1 million. Yeah, because if you think about, that's the foundation. I would assume the house would have had to be rebuilt based on that kind of damage assessment. And who was liable in this? Who made the error in the court's opinion?
The owner.
Not the owner.
The delivery, the first company, the oil delivery.
The first one. Stanzel.
Because they left it.
Because it was, a mistaken oil delivery was foreseeable. It was foreseeable that an employee might misread a delivery ticket, might attempt to rotate a fill pipe that had come loose over time, and might use a wrench to open a tight cap. Combining reasonable foreseeability with the enormous potential harm and the trifling cost of permanently plugging the fill pipe, I conclude the respondents breached the standard of care. I have a problem with that.
Because there is a clear instruction, and the problem with the guy, that he couldn't follow the instruction properly, so why they stand on it.
So this seems to be an example of the court saying, sort of applying this idea that we've already looked at. Well, the cost of the cure was just so minimal compared to the cost of the damage that could have ensued.
But this is about the standard of care. First, we have to establish that there is a duty, and the
Which they found.
The foreseeability is very difficult to say that it's easy. Because there was a practice, I think, in the area that you have it signified.
Well, even more than that, I wonder what was the driver thinking? How do you preclude that? Do you have to hold the guy's hand, make sure that he's read the ticket properly? This just seems, to me, it's the delivery company that's at fault, not the people that decommissioned the tank.
Years ago.
Yeah.
Obviously for years, right?
Yeah, so I have trouble with this one. And I put in the dissent, who accepted the trial judge's view that a reasonable person would not have conceived of it as possible that a trained oil delivery person would make a mistaken oil fill into a turned down fill pipe with a tightened cap. that just isn't, that doesn't breach the standard of care. And so, what do we take from this? Well, I think we have to take the idea that it's incumbent on you, if you go to court, to make the court very clear as to what's going on. Because I think here the court just misunderstood a lot. Unless they were related to the delivery.
Maybe he was delivering to the judge's place.
Or a former neighbor. So, and you will see this. I've seen it. Judges get the law wrong. It's incredible, but they do. And you can't necessarily tell them. But you have to subtly guide them towards what the proper issue is, supported by the case law. Here, as I said, I think the court just took that kernel. If the cost of the cure is so cheap, then they must have reached a standard and apply it, when that doesn't fit the facts of this case. So if we look at Lovely and Kamloops, Lovely goes to a dump, basically, to drop off garbage, and in doing so, falls into the garbage can and injures his leg to the point that it has to be amputated. And he sues Kamloops City. Kamloops probably says, "You're the idiot that fell in." But the BC Court of Appeal said, well, you could have just put guardrails around. And they even gave the cost, about $4,500 would have been the fee for that. So I think here, Lovely is a more appropriate assessment than we had in Bingley, because it's saying, well, in terms of the cost compared to what could have happened, here you have a person that lost his leg, all for the want of guardrails. So when weighing the the financial cost, we have here with the cases parameters. We have certain guidelines as to what the courts will apply in terms of assessments. What's the cost of prevention? If it's a low cost, the court will side with the standard having been breached. But keep in mind, Lovely, the cost was $4,500. You could say, well, that's a lot. But within that, and one of the other medical cases, the argument is, well, what's the cost as compared to what will be lost if you didn't do it? So here we have a scope for assessment that the court is charting. We may not agree with how it's applied in every circumstance, but we have with these cases authorities through which we can argue either side.
I was just going to say that, it's easy to say 4,500 in this one instance, but I presume that the Kamloops city or municipality operates several of these stations, transfer stations.
Yeah.
You've actually got to extrapolate it out and work out what the cost is kind of across the...
Yeah. If that argument, I don't know if that was argued in this case. Certainly that could be something. I think, when you make that argument, you have to weigh what are you up against. And maybe it may be a crude way of putting it, but Lovely is a sympathetic plaintiff. The guy tries to be a good citizen to dump his garbage off at the dump. and loses a leg. You know, I don't know if you can necessarily overcome that kind of a scenario. So I mentioned that not to negate the point, but to say, assess what you're up against. Social utility. Plaintiff firefighter responded to an emergency call requiring the use of a special jack. Jack had only been used once in 15 years. The truck that was fitted for carrying the jack was unavailable, and so they loaded it into the rear of another vehicle. Nothing goes wrong there. The driver braked suddenly and the jack became dislodged, seriously injuring the plaintiff. And the court says, that's too bad, but you have to measure due care against the balance of the risk that the measure is necessary to eliminate the risk. Which is kind of unfortunate for the guy who's now injured. Fiala and Catchman, a couple of cases down. If you ever have a case where a defendant says that he had a plan from God, and you're wondering what the standard of care is it in fact some supernatural standard of care? The court doesn't hold you to that. It would be irresponsible of the court to hold somebody liable for actions which they do not have any knowledge of or any conception of wrongful conduct. So if somebody is mentally incapable, it's hard to hold them to the reasonable person standard, for the simple reason that they probably don't fit within the reasonable person category. But that brings up, is the standard of care malleable? Does it change? And I think we find that it does. We know here the standard of care for children and then parents. You have the Parental Responsibility Act, which finds parents responsible for their children. But we see this probably most clearly in the standard of care applied to professionals. Because if we're talking about a reasonable person standard, when the harm deals with something medical, that's a tough measurement. How can we say the reasonable person when it's a doctor doing his or her job? The reasonable person standard
Should be a reasonable doctor.
Yeah, we need to modify that. So we modify it to, well, what would the reasonable medical professional have done? So Layden and Cope, Layden had gout, went to a few doctors, it progressed to the point the leg had to be amputated, a bit of a theme, and the doctors were liable. The doctors were saying, well, we're just general practitioners in a small town. And the court basically said, that's nice. That somebody who is a citizen in a small town as compared to a citizen in a city should be able to expect a uniform level of care, a basic level of care. That a doctor in a small town versus a doctor in a city, if that's what the doctors in the small town were alleging, have the same standard of care. We don't modify it based on what you normally don't see. In that case, the doctor should refer the patient to another specialist. White and Turner, the defendant was a plastic surgeon who performed breast surgeries for women, performed breast reduction surgery on the plaintiff. Plaintiff suffered several post-operative complications resulting in her breast being scarred and poorly shaped. So she sues the doctor based on negligence. What's the standard of care? Or to succeed in an action against a professional person, the plaintiff must prove on a balance of probabilities not only that there had been a bad result, but that this was brought on by negligent conduct. In this case, the plastic surgeon had conducted the surgery in a very rapid manner and did not perform a standard check after the operation. So the courts here with White and Turner are signaling, let's not only look for if there's harm or something bad would happen, something bad happened. That bad occurrence has to be linked to the negligent conduct. Not all bad outcomes of a medical procedure are the result of a doctor's negligence. In this case, the court found that on a balance of probabilities, the rapid pace and rather careless failure not to perform a standard check suggested that there was negligence, falling below the standard of care. Myers and Moskowitz. Sorry.
So, does there have to be some permanent damage with the patient for the doctor?
It doesn't have to be permanent damage. Let's say something. I saw a commercial for insurance, I think it was, where the doctor left his cell phone in the patient, and they were talking to the patient, and Siri was responding. Let's see if I can find out how to get the phone out of you, something like that. So would that be permanent? Yeah, probably not. Like assuming everything was fine, but certainly there's some harm suffered. So it would be spoken to in terms of the quantum, the amount of damages awarded.
And that's Canadian law. I'm asking because, so I recently did a C-section, right?
Okay.
And this doctor did not suture like the two ends of my incision.
Okay.
So my belly was like wide open, got infected, all that. And that was the argument, that there's no permanent damage, so this doctor isn't negligent.
Who made the argument?
A number of law firms.
Oh, really?
Yeah. So I was surprised reading this.
It has to be permanent and serious, otherwise nobody pays anything.
Maybe a financial decision was made, like I don't want to speak for them, but they may have felt that there wasn't the damages wouldn't be a lot.
Yeah, but I didn't even approach them regarding the damage. My issue was just, okay, you're negligent and we're trying to ensure that this doesn't happen.
Yep.
Again.
Yeah.
However, so that clarifies that question.
So, well, the Myers case gets into this kind of thing. The trial judge erred in defining the standard of care expected of the reasonable doctor in the management of the birth. Instead of framing the standard in terms of the overall management of the birth, the trial judge focused on a single aspect. In this case, the monitoring of her temperature for infection. So, when we're looking at the standard of care, and we're asking, well, what is the standard? If it's for a doctor, we've modified it, but what is involved in that standard? The trial judge said, well, the doctor was not negligent, did not fall below the duty of care because he monitored for infection. Arguably, that's, and in fact, this is what the court found, that's not a proper standard because the management of a birth is not simply a matter of managing of infection. There are other factors that go into that. So why I point out this case is the standard of care can be construed in an advantageous way. Not just a low threshold or a high threshold, but also a narrow conception of what was the standard. So if you have to monitor if generally you monitor 5 things, but you're only held responsible for not doing one of them, and you do that one well, but you do 2 other things incorrectly, the trial judge would have found that doctor not negligent. The Court of Appeal corrected that in Myers by saying, no, it's the overall management, not a narrow definition of what constitutes the standard of care. In the final case, Ter-Knudsen versus Corin. So, you might have seen stories from a while ago about tainted blood. So you donate blood to the Red Cross, and unbeknownst to you, you have an infection. In Ter-Knudsen, it was HIV. Now, this case dated, I think, if I remember correctly, back to the 1980s. So, the plaintiff contracted HIV through a specimen that was not checked for HIV, and brought the case at a time that checking for HIV was widely done. The problem was the operation was done back when HIV was not something that was checked for. So what is the standard of care in that case? Do you say, well, HIV is deadly? You have to monitor for all deadly bacteria, infections, whatever it may be. Or do you say, well, that was not the practice at the time, that we couldn't hold the medical professionals responsible for a standard that we now employ, but that was not employed at the time?
I think it was not even known that it was possible, this transmission done through. So how can we hold them liable with the knowledge that we have now for something that was not known? It was not known that it was possible.
Right.
And it was something new, like.
So the way I phrased it was in a way to be a bit sympathetic to the plaintiff. Because in the end, the plaintiff has HIV.
Yes, but there must be somebody's fault in us to have a thought.
But the plaintiff's problem is, arguably there was fault, but there wasn't knowledge that carelessness was being
How come we have
employed.
fault when we don't know?
No, that's what I'm saying. I'm not disagreeing with you. But it's more, so the court says we cannot hold people to standards of care that are revisionist. What I mean by that is, if we now know this is what should be done, we cannot go back to the 1980s and say, well, you should have done that when it was not the custom at the time to do that test. But if I'm the plaintiff, I'm still not happy with that.
And the jury found that the standard was weak, but the court found that the judge should not address this issue to the jury.
Yeah.
Because I'm not familiar with jury deciding civil cases. So, just to clarify, so when the jury decides if there is evidence to be evaluated, or in any case, it's up to the jury.
The question would go to the jury. Was it the responsibility of the defendant? And juries, I think, when you're presented with this individual who's suffering HIV.
No, it's not. I think it's probable that they will decide for the defendant.
Yeah, and the court is saying that question should not have gone to.
At all.
Yeah, because simply put, it's an unfair question. We're holding the doctors to a standard at a time that was not the customary practice.
Should the judge say the question or should not address the question?
The judge should not have put that to the jury, that question. So the jury should not have been determining that part. Yeah.
I have a little bit of problem because it's not that HIV was not known by that time. It was not widely known. I mean, if you are in insemination business, you should check, you know, if things are getting known.
Yeah.
I mean, it's like there is a new case 2 weeks ago, and if it's relevant to your case, you're supposed to know, right? Even if it's only whatever, two months old. So it's the same thing. If HIV was already existing, it was known.
The way of transmission. I'm saying that because they knew about the virus, but
I'm not saying specifically in this case, but the question is when there is a new research or there is new evidence, for how long you are patient with the medical practitioners to put their practice, update their practice.
But that comes down to, was it customary? Was there a custom practice at that time? Not, was this known to be potentially a problem? So there had to be a decision by the medical community that this is standard practice, and that had not occurred at that time.
in Australia, there was first report that it's possible, like it seems normal to us, but back then it was something like a mystery.
I understand. I'm just questioning if the medical professionals don't care about evidences for 5 years, and it's not a custom, then for 5 years there is no detailed care.
Yeah, but so that's why it comes down to the medical bodies. Sorry, there were two questions, just very quickly.
Basically, they can protect the mechanism.
Yeah, but I think the thing is, the question is, how quickly are they supposed to act on that? And I think it takes a while for things to be accepted by the medical body that this should be done. And within that time. Right. I understand.
就付一部分嘛，这个钱的确是不能用，但是可以 transfer 到他的款款。
Sorry, there are two questions.
Yeah, on top of the point just raised, I want to say that whether the benefits, the cost analysis also try to that the medical community is reluctant or slow to implement a new standard, higher standard. But in the eyes of the cost, because the cost means the damage is so deadly to the patient, and yet the cost to conduct the diagnosis is so low, then
it would be up to the plaintiff to show, combining your points, that the medical community was too slow or that this was not acceptable.
Yeah, you was can be acceptable.
Yeah, but you have to establish that.
Yeah, so you touched on that, but from what I recall from the UK, that was the standard that's held in a substantial medical body consent, as a general consensus of that type of, I guess, like care, the standard care. So it's like, it could be in those circumstances that perhaps there's one general practitioner, one specialist knew about the whole, the medical aspect of it, but it could be just a larger body whole, more of the standard, which is like the case I feel like, just in general today too.
So, Wednesday? Yeah. Wednesday we look at causation and remoteness, and then next week we start into representation. The remedies again, we're not going to do.